So, this is Resistance Radio, and I am John Kane, and we are broadcasting from the Cattaraugus territory of the Seneca Nation. Of course, we're recording it as well. We put this show up as a video on YouTube and on Facebook, and of course, I posted up as a podcast as well. Again, it's great to do a radio show in two of the main media markets that mean so much to a native voice like mine, and that being New York City and Washington D.C. So today, I'm going to start off by just flat out saying it. I don't care what the Constitution of the United States says, treaties are not the supreme law of the land. It says it is, but it isn't. I mean, they aren't. I mean, and I think we are. I'm just not just talking about native treaties. I'm not talking about this the 100 years of negotiating and deceiving native people through the use of treaties. I'm talking about treaties the United States enters into in general. We know the Iranian nuclear treaty that the United States entered into that Trump simply just walked away from. Many of these other agreements, whether you want to call them treaties or not, whether they are tied to climate change or anything else, on a whim, a president can just walk away from them without really having any consequence other than the consequences of not being in an agreement. Of course, Congress also has the authority to abrogate any treaty it wants. And of course, this really was developed out of the conversations associated with native treaties, which in 1871, they essentially ended treaty making with native people. The Congress, again, passed a law. It was an Appropriations Act, actually, where they basically declared that we are no longer considered independent tribal nations, sovereign nations, whatever the words they used, and as such, no longer warranted the whole treaty making policy that existed between Native people and the United States and the countries that preceded the United States as well, but mind you. So this is so where did that leave us? In 1871, we still weren't U.S. citizens. So we were kind of left in this no man's land. We had all these treaties, and there were hundreds, in I guess over 300 treaties that the United States drafted. We never drafted any of these, by the way. And I think it's worth noting that Native people never prayed or pursued a treaty with the United States. Not to surrender a treaty or anything else. This was always something that was pitched to us as a means to maintain, sustain, create peace, if you will, and harmony. And of course, it was all lies. And every treaty the United States ever entered into with Native people, they broke. But I want to back away, not just to complain about treaties, and I'm going to do more of that yet, but I just want to put things into their proper perspective. You see, even though the Constitution lists treaties as being the supreme law of the land because they are a U.S. law, there's no mechanism that says, well, how do you get out of it? So courts have basically given Congress power that the Constitution never has. And of course, the Constitution gave the president the authority to negotiate treaties, and those treaties would come into effect or they'd be ratified with the advice and consent of the Senate. Two-thirds of the Senate, mind you. Now, most Native treaties were never properly ratified, either by the U.S. side or by the Native side. They never were. I mean, they put a bunch of words on paper. They had a bunch of Native people either put an X or a mark or something like that. Not a whole lot of signatures on these things. Never any real indication that what we were putting our mark to was what they were telling us was written on those papers. Again, we had a bit of a language barrier issues. And in fact, the courts have actually held under their canons of construction where they said that if there's ambiguity in a treaty or a contract with Native people, it must be interpreted with some bias towards the Native interpretation. Because basically they said, look, you guys, and this is the court telling the United States or whoever the other party is, this is what you do. And it's not what they do. So if you can't construct an agreement, a treaty, if you will, without ambiguity, that's on you. And if we as a sitting judicial body can see, yes, there's ambiguity. We're going to rule that ambiguity on the side of Native people. Now, that's what they said, and that's what is listed in under the court's canons of construction. Doesn't mean they do that, but they did say it. Of course, they've said a lot of things over the years. Um, the thing is that from a Native standpoint, I refuse to be defined by a treaty because most of these treaties were about the United States wanting something. And whatever we were willing to give up was explicit, and usually it was land. I mean, and it never suggested that we were somehow surrendering ourselves under the authority of the United States. And I was just listening to a podcast by Peter Dorico and Stephen Newcomb. They were talking about tribal sovereignty 101. That's the name of the podcast. Look it up if you will. It's in their Substack. But one of the things they start off with was addressing the Cohen Handbook on Federal Indian Law. And of course, it's been updated. It was originally written, Felix Cohen, in like the 40s or something like that, 1940s. And it's been updated since. But one of the things that they say in this handbook, because it's really confusing, the whole notion of quote unquote federal Indian law, which is, as Peter Dorico calls it, federal anti-Indian law, because every one of those laws is about us without us. And they are usually against us in some manner. So, but it's confusing because there's never any explicit means by which they say the United States gains certain authority. And in this handbook, that is considered the Bible by many accounts of federal Indian law, it says that the Native people became under the authority of the United States through both force and treaty. So they're basically saying that the treaties were used to place us under the authority of the United States. Now, none of the treaties actually say that, and they don't cite any examples of that. They cite rulings on treaties that may have said that, but not the treaties themselves. So I will never allow a quote unquote Indian treaty, a treaty between a Native party, certainly not, the Haudenosaunee, and the United States, define my existence. It may have defined certain things. And I'll say another thing. I don't mind citing language from these treaties, even if they weren't properly ratified, just to demonstrate the hypocrisy and the deceit that the United States engaged in with treaty making. Because I maintain to this day that every treaty, including every treaty negotiation, was an exercise in fraud. Because the United States never intended to follow any of their promises made in these agreements. They were trying to just fill a gap. They were trying to placate us to some extent for the time being till they could better their position so they could ask for more or demand more or claim more. I mean, oftentimes the United States was legislating and passing laws totally unbeknownst. We weren't even a part of the process, but they would do all this stuff unbeknownst to us, and we wouldn't even find out about it sometimes till decades later. They passed the Indian Citizenship Act in 1924. Most Native people weren't even aware of it until draft registration started showing up for World War II. I mean, because what was happening in Washington wasn't happening in places like here on the Cattaraugus territory of Seneca Nation. And we're in the East. If you were farther out west, you even had less communication. You had less conversation and connection to what was happening in Washington or any of the state capitals for that matter. So when I hear Native people say, well, treaties are the supreme law of the land, no, they aren't, because they can cancel them. In fact, the courts have essentially ruled, the Supreme Court has ruled, that Congress can abrogate a treaty without even knowing they're doing it. They don't even have to be explicit about it and say, okay, we're changing our position. No, they don't have to say it. If they pass some law or policy or enact some policy that violates a treaty, as far as the courts are concerned, that's their prerogative. And especially with this notion of the plenary powers doctrine, where the courts have basically created this unique and explicit power that only Congress has, and only over Native people, which is to say they can pass any law they want about us. There you have it. So if Congress can do whatever it wants, and apparently the president of the United States can do whatever he wants, and regardless of whatever treaties the United States has entered into, then they aren't the supreme law of the land. Apparently, Congress and the president are the supreme law of the land. And then it turns out that the courts get to maintain and decide what is actually law and what is not law. And when it comes back to that plenary powers, and I've talked about this on previous shows, the courts have basically said, it's not our job to scrutinize or hold that power accountable. Whatever Congress wants to do, it can do. And it can't be challenged. In fact, again, when that family from Texas was trying to challenge the Indian Child Welfare Act, they said, well, not only did it get thrown out because they claimed they didn't have standing, but they basically said, under the plenary powers doctrine, Congress can pass whatever law they want regarding Native people, and it can't be challenged. So this family from Texas that was challenging the Indian Child Welfare Act, they said, no, you're dead in the water. You don't even pass go. You can't even challenge this. So if you want to make a constitutional challenge about the Equal Protection Clause of the 14th Amendment, or if you want to, challenge any kind of other racial discrimination or overreach of the federal government into states' rights, no, you can't do it. Now, you can do that with other things, but you can't do it with anything Congress has passed relating to Native people. Well, then what about the so-called treaties? And again, let me reiterate, every one of them has been broken at some level. I mean, the one treaty that gets cited all the time for Native people here in the Six Nations, Haudenosaunee, is the Canandaigua Treaty. It says 3 times in that treaty that the United States recognizes that our land is ours, and it talks about the Senecas, it talks about the Cayugas, it talks about 3 of the 6 nations it mentions specifically, but it says they will recognize that our land is ours. I mean, that's possession, that's property, that it's ours, and the United States will never claim the same nor disturb our friends and allies living amongst us in the free use and enjoyment of that land. I mean, you can't be more clear than that. It says that 3 times. But that's 1794. 30 years later, you've got Chief Justice John Marshall saying, oh, no, you don't really own this property. We don't recognize that you can actually hold title to the land. Well, what was the language of Canandaigua then? See, they break it almost immediately. And the court, in this one, it's not even Congress that breaks it. It's the courts that do. And so the question ends up being, when you go through that Marshall trilogy of cases, the Johnson v. McIntosh, Cherokee versus Georgia, and Worcester versus Georgia, those 3 cases, you're left wondering, well, wait a second. Where do Native people exist within the framework of the United States? Well, we never did exist within the framework of the United States. We weren't a part of the Constitution. We were only included in the Treaty Clause and in the Commerce Clause. We were excluded for any kind of counting of our bodies in terms of for representation or for taxation or anything else. No, we're excluded. It says it specifically. But then we're included in the Treaty Clause and we're included in the Commerce Clause only in as much that the Commerce Clause says Congress shall have the power to regulate commerce in and among several states with foreign nations and with Indian tribes. With, not of, with. So it uses the exact same language with Native people that it used with foreign governments. And that's why treaty making with Native people was taken in the same, within the same mindset, the same process that treaty making with other countries would be. So we were treated as foreign nations. That's the way we were treated. So, I mean, that's the way we were. I mean, that's just a matter of fact. So I think it's sometimes not real clear how this really all plays out. And until you realize that the United States doesn't follow its own laws. And when it comes to Native people, they created a whole separate means for dealing with Native people that's outside of any of their constitutional limits. Because, again, let me say this, just so people are clear. The Constitution the whole point of it is to show the limits of government and the function of government, what it can and what it can't do. The Bill of Rights, the amendments to the Constitution, all of those things are laid out there to say, hey, this is where we can't go. And we can talk about gun rights, and we can talk about freedom of the press and freedom of religion and all other stuff, and the right to assemble, all these things. But they make it very clear. These are your rights, and we can't infringe upon those rights. So that's what the Constitution and its amendments were supposed to be. But we're not in any of those. I mean, right up to the 14th Amendment, we're still not in them. But somewhere along the line, you have the courts that keep beating the same drum. Oh, Congress, you can do whatever you want to Native people. And even though we're not part of the U.S. citizenry, and what they did is they suggested that we were somehow too ignorant to be included amongst them, but perhaps we should be treated like wards of the federal government. So how do you have treaties with a party that you think are incompetent, that you've placed yourself as the trustees for? So who are you negotiating treaties with? And to be clear, there were none negotiated. These were drafted. They were either rejected out of hand, or we put a mark on them. And there's no evidence that we ever went through any ratification process on our side. And we have them. I mean, within the Haudenosaunee, we basically have within our Guyana-Lagoa a requirement that says if the Mohawks specifically aren't involved in a negotiation or even a Grand Council, then the Grand Council isn't a legitimate meeting. It's not a legitimate session. And so when you take something like the Canandaigua Treaty, it wasn't signed by any Mohawks. It wasn't marked by any Mohawks. So it wasn't ratified properly on our side. And frankly, most of these weren't ratified by 2/3 of the Senate either. And again, we're not just talking about Native treaties. I always have to include my brothers and sisters in Hawaii. There is no annexation treaty. There was ever a treaty that was negotiated by the President of the United States and then ratified by 2/3 of the Senate. It never happened. What they did do, rather than using the constitutional process for treaty making, including annexation treaties, they violated all that and said, well, we're just going to take in Hawaii through a joint resolution of Congress, which isn't the process. It's illegal. And they knew it. There were congressmen who said, so we're just doing this because it's the only way that we can do it, even though it's illegal. They knew it was illegal. So the whole idea of acquiring or taking over or occupying Hawaii, it was a clear violation of the U.S. Constitution. And they even apologized for it. 1993, under the Bill Clinton administration, they issued an apology resolution. And here's the kicker to this one. And I always got to bring this up. They used the joint resolution of Congress, which isn't its function, to claim to have annexed Hawaii. They also did a joint resolution of Congress to apologize for their illegal occupation, essentially, of Hawaii. But though that apology resolution was used in court proceedings, the Supreme Court says, oh, no. You can't use a joint resolution of Congress. That's not a law. And it has no legal authority. So wait a minute. A joint resolution by which you took the land, you're saying is valid, but a joint resolution where you admit what you did was wrong isn't valid? I mean, the hypocrisy just is just remarkable. And again, for me, the only value that these treaties have is the fact that we didn't write them. They were always written by the United States or its representatives. And the language that was chosen, they chose. So I don't mind pulling out these treaties and say, look, what you said here isn't what you're doing. So it's real easy for me to pull like the Canandaigua Treaty and say, look, this is what you wrote. This is what you agreed upon. We can argue whether it was ratified properly or not, but you're still sending treaty cloth to us every freaking year. So you claim this thing is valid, and yet you violated it. You violate the language of the actual. So I can show you where you are being deceitful if not hypocritical, actually probably hypocritical and deceitful, you're lying. When Chief Justice John Marshall says we don't own our title to our lands, well, that's not what the treaties that you negotiated with us said. And not just with us, you did it with hundreds of other, or maybe not hundreds, but with many, many other nations. You acknowledged our rightful ownership of our lands. And then in 1823, Chief Justice John Marshall, you talk about legislating from the bench, he just basically voids all of those treaties by saying, no, you don't really own your land. Under the doctrine of Christian discovery, he codifies a church doctrine which negates every treaty that recognized our property rights. So there we have it, right? So no, I have major problems, and I understand why people sometimes try to cloak themselves or wrap themselves up in their belief in these treaties, because some of the language, it sounds good, but then when you realize the United States isn't acknowledging or keeping its word, and then when you see that under their handbook on federal Indian law, they believe that the treaties were used to put us under their authority. Well, how do we use that to protect ourselves from their authority if they're saying that's what they use to place us under their authority? So again, I think there's language in the treaties that's worth citing and worth mentioning, but I will not allow a treaty to define my existence. As Ungwe, as Mohawk, Ungwe, Gunagahaga, my existence is defined not just through the last 100 years or 200 years, but through thousands of years. My existence is defined through our language, which still exists today, that predates the United States, that predates Europeans in general coming to this land. So no, I have a major problem with anybody who says, well, I'm a Treaty 6 Indian. And that's what they say on the Canadian side. Oh, I'm treaty this, I'm treaty that, I'm a treaty Indian. Well, what the hell does that mean? I mean, the U.S. and Canada never entered into these agreements with any real honor. There was never a negotiation. There was never any free, prior, and informed consent associated with these things. And the violations of these things always go unnoted. They've taken our children, they've taken our resources, they've taken our land, they've taken our lives. And they're never held accountable. So I'm not going to honor an agreement with a country that lied to our face and continues to lie to our face. And the thing is, most people know that the United States is violated. I mean, you could ask any American, well, has the United States honored all its treaties with Native people? And they're all going to say no. No, they haven't. Because even if they don't know the specifics, they just know in general that's never been the case. They know it. The average American knows this stuff. And yet the average American who even knows we still exist, they at very least see us as different from them. I mean, I've heard, Americans say, well, you're like a nation within a nation. Well, I'm not sure I like that analogy, but I understand where you get that. I understand that. So you acknowledge that we are not you, that we are something distinct. And look, most people know when they've entered a native territory, even though many territories, because of land allotment and everything else, have become so checkerboarded that it's sometimes difficult to tell which parcel is native, which parcel is non-native. I mean, and the crazy part about it is it's all might be reservation land, but there may be white folks living there because they have somehow purchased some sort of deed to the property through the allotment process. I mean, it's really pretty remarkable what Native people have experienced at the hands of these great treaties that were negotiated. And look, we can see it time and time again in every instance where Native people have been screwed. And then when we do cite the treaties, we either get hit with this notion, yeah, but we abrogated that treaty. We that no longer is valid. Says who? I mean, if you don't come to the table and say, look, we've got a problem with this treaty that we entered into 100 years ago, and we think we have to adjust it. Those conversations never took place. Congress just does whatever the hell it feels like doing because the courts have allowed them to do it, and the presidents have encouraged them to do it. And of course, the presidents, it's the same thing. I mean, this idea of putting land in designated land as a national monument to somehow protect our interests, that doesn't give us our land back. So whether you're Obama or Biden or anybody else who says, well, we've done these, we've taken these, these major actions to protect lands for indigenous rights. Not if you turn them into national monuments. You're not calling them our national monuments. You're calling them yours. And then you turn around, then the next president comes in and trims it down. Trump says, well, we're going to cut that in half. We're not going to recognize the national monument that Biden or Obama put in place. No, we're going to gut that, and we're going to put a copper mine in there. Yeah, so, I mean, you can't make this stuff up. Oh, I always say that expression. My buddy David says, you always say that. But that's exactly what they do. They just make this stuff up. In fact, Antonin Scalia used to say, well, when it comes to Indian law, we basically just make it up as we go along. They don't have any standards. There's no accountability. That's why even among the right-wing justices of the court, there's some of them that just scratch their head and say, we don't know how we got away with this. We don't know how we created this trust doctrine. We don't know how we created this plenary powers doctrine. We don't know how we can still maintain the premise of the doctrine of discovery, and they still do. I mean, this stuff is still being cited today. They're really crafty sometimes. They won't actually call it doctrine of Christian discovery. They'll refer to the case Johnson v. McIntosh, that's what they're talking about. They'll talk about settled law, but what's the law settled on? Well, the law has been settled on this notion that Christians could take our land, and that we, in spite of the treaties that were supposed to be the supreme law of the land, that the United States could claim the title to our lands. That's what they've done. And it's not just the United States. I have to remind people, in our film, The Long Hope, we talk about the Tehitan case, because there was this case that was ruled upon by the same court that recognized the racism in Brown versus the Board of Education. That same court, a year later, would rule in a case involving the Tlingit, which is a West Coast in Alaska territory, native peoples, that said, look, you're taking the trees off our land. We expect at least compensation here. And the court basically said, that same court that could recognize racism in education said, well, we can extinguish your right of occupancy without compensation. We can take your resources without compensation. We have the right to do that. And again, what do they cite? The doctrine of Christian discovery. That's where they claim to have this power. So look, when we talk about Brown versus the Board of Education, we're talking about the 20th century here. We aren't talking about the 18th century, the 17th century. We're talking about fairly contemporary stuff. And none of the basic policies, it's one of the things that I said on a previous show. The fact that these things existed is crazy all by itself. The fact that these things still exist and that these policies continue and that they continue to be cited today, it's the still factor that is amazing to me. Because, and I've always got to bring this up, nobody has this kind of policy created to put them in boxes the way we have been. Nobody else. I mean, look, the U.S. Constitution doesn't mention women. It doesn't mention black people. It doesn't mention immigrants. It does mention, people who might be free and unfree, but it doesn't say who they are. It even mentions indentured servitude, that termed indentured servitude. So it mentions that stuff, but it doesn't single out anybody in particular. So that's how when the arguments come against slavery, and yes, we can interpret this fully as a black issue, but the Constitution never cast black people as a people that could be exploited like this. It never mentions them. So it's reasonable to expect that black people are every bit as uh, should have the same protections as anybody else, because the Constitution doesn't say they shouldn't. So why shouldn't those constitutional protections apply to black people or women or Chinese immigrants or Asian immigrants or South American immigrants? Yes, the Constitution doesn't single out any specific people except us. We are the only ones, we are the only human beings as and I say a group, but we're obviously a pretty diverse group, but as a people whose main common thread that we share is the fact that we predate the United States. So the people who were here first are the only people who are mentioned specifically for exclusion in terms of counting us, in terms of regulating commerce with us and foreign nations. So we're the only ones who are not included. Arguably, even if the founding fathers of the United States didn't plan on women having rights or children having rights or immigrants having rights or black people having rights, they didn't say it. And that's why you could argue that it was unconstitutional. That's why Brown versus the Board of Education, the ruling was there. And the distinction between that same court that could recognize that the Constitution should be protecting the education of black children did so because there's no exclusion. There's no specific set of language from the Constitution that says they could do something to black people and nobody else. But we are mentioned specifically in the Constitution. And because of that, we have always, that same court that could understand the constitutionality of education couldn't understand the constitutionality of stealing our land and our resources because we were singled out and treated differently. And we are still. So I have to mention all of this stuff because I don't think people realize when we cite a treaty that we're not defining ourselves by that language because it's not our language. And even though your courts have claimed that the ambiguity of these things should always be interpreted through the eyes of Native people, they aren't. And if they are, then they become abrogated. I mean, the courts know that taking the Black Hills violated the Fort Laramie Treaty, but they didn't say, okay, well, we got to surrender the land back. No, they said, well, then you've got to accept money for it. We're going to force you to buy it. We're going to force you to sell it to us then. So the Lakota said no. And then because you have the United States claiming that we are too incompetent to represent ourselves, that we are considered wards of the federal government, you have the United States that can serve as both the violator of a treaty and then serve as our trustees to accept the terms that they've negotiated with themselves. I mean, this is like governmental masturbation because you basically have the United States playing with itself in almost all these regards. And when Native people have said, hey, wait a second, we want to know the details of that mining contract that you negotiated on our behalf. They said, oh, no, you can't. We can't give you that. Well, what do you mean you can't give it? Well, that's lawyer-client privilege. Well, but we're the client. No, you guys are the wards of the federal government, but the trustees that we have appointed for you, which is us, we don't have to give you the details we don't have to violate lawyer-client privilege because we don't have to recognize this trust relationship as a legally binding, detailed trust. No, we just use language like that so we could take advantage of you. And they admit it. I mean, they say it. Sam Alito did this long list of examples on how the so-called trust responsibility and the trust relationship isn't really a trust. That it was established specifically to take stuff from us and to enable the United States to advance its agenda first. Oh, they could consider the welfare of Native people. They have to take it into account. But they are the primary beneficiary. They are the beneficiary of the trust. They are the trustee, and they are the grantor that created the trust, which isn't really a trust because there's no documents to it. So, I mean, I know I talk about this stuff on the show a lot. And I make no apologies for that because this conversation isn't happening where it needs to happen. I mentioned this a couple of weeks ago. The UN Permanent Forum on Indigenous Issues. Every year they meet for sometimes 2, 3, 4 weeks. And nobody will hold the United States accountable for the fact that they still have legal doctrines that under the third affirmation of the UN Declaration on the Rights of Indigenous Peoples says all doctrines, policies, and practices that are based on the superiority of a peoples, based on race, religion, national origin, are racist, scientifically false, legally invalid, morally condemnable, and socially unjust. The only thing it doesn't say, it says legally invalid, but it doesn't say that it's illegal. It doesn't say that that those policies are crimes. And nobody will bring it up. Oh, we'll get people to go to the Permanent Forum, talk about missing and murdered Indigenous women. We'll get some people to go in there and testify about residential schools. We'll get some people to go in there and talk about the fact that we're still losing some of our children to foster care and adoption agencies. We'll get some people to go in there and complain about a bunch of things. And these are valid complaints. The problem is we never address what made any of these unlawful activities legal. We never address them. And even though the UN passed this Declaration on the Rights of Indigenous Peoples, it has no enforcement mechanism. In fact, other than the Permanent Forum where our people can go to, I guess, list grievances, there's no place to hear the grievances and make a determination. There's no means for Native people to prosecute the United States or Canada or any Indigenous people, for that matter, prosecute a government, a nation state, for violating the articles of the Declaration on the Rights of Indigenous Peoples. And the United States has violated most of them. There's a thing, and so has Canada. There's a recent conversation. There's this premier of Alberta or someplace, I don't know where he's from, but this guy by the name of Wab Kinew. And he's one of their ministers or whatever they call themselves in Canada. I don't know. But he's trying to push through a pipeline through Native territories. And of course, Native people are saying, oh, hell no. We don't want a pipeline through our territories. He says, well, before we try to vote on this thing, we need to make sure that it's on us to do the consultation. And I said, consultation? Well, that's BS. The UN Declaration on the Rights of Indigenous Peoples doesn't call for consultation when there are policies or initiatives that are going to impact Native peoples. Not even just on our lands, but even if they're away from our lands, but they're going to impact us. What the UN Declaration has said is that it's requiring of nation states to get free, prior, and informed consent from Native people. Now, you might get that through consultation, but if you're saying, no, we don't have to get the consent, we only have to do the consultation. So we just have to have you come in the room, sit at the table, we're going to tell you what you're going to do, or what we're going to do to you, and then we're going to check the box and say, there, we consulted with you. Well, no, you just told us something. You didn't ask us our opinion. And then I've heard people say, well, that language in the UN DRIP basically gives Native people veto power. Well, why wouldn't it? Why wouldn't we have the final say? Now, look, if there's something that you could do to somehow sweeten the pot enough that we're willing to sacrifice something that is in your best interest as well, because you wouldn't even be talking to us if it wasn't in your best interest. If there's something that you can grant us or give us that we don't already have, that would convince us, okay, we're going to give you a right of way to put this pipeline through here, but we're going to negotiate certain protections, and we're going to negotiate certain oversight over that. And we don't just want compensation. We want to make sure that for any land that we sacrifice, that we are that other lands are returned, or something of that nature. That's what free, prior, informed consent means. It means that you negotiate, you consult to reach consensus. And look, and if you can't convince all of us, then it's not consensus. Just because somebody, that you advance somebody through the Assembly of First Nations or through the National Congress of the American Indians or through your federal recognition process, that individual doesn't have any authority unless we gave it to them. Your recognition isn't the authority. FedRec, and I spell it WRECK because that's what it is. FedRec should not be granting Native people authority from you. The only authority Native quote unquote leaders should have, and they aren't leaders, they really should be servants, is the authority that we give them. And if you're going to somehow say, well, we consider you to be the lawful signatory to this agreement, based on what? If you don't have free, prior, and informed consent for us that we've granted somebody that signature authority, then they don't have it. I mean, this is all common sense, right? I mean, I don't think I'm saying anything that a logical person can't agree with. But see, what happens is we have been regarded for so long as somehow ignorant, incompetent, unsophisticated, uncivilized, savage. Those are all the words you've used. We lack the superior genius of Europe, is what you said. And it's only going to be through the process of forced assimilation that we could ever truly be considered a lawful citizen. Because even though you passed the law in 1924, a little over 100 years ago, that declared we were U.S. citizens, you never took off the ward status. You never said, okay, we're no longer going to consider you wards of the federal government because now we're going to grant you full-fledged U.S. citizenship. Well, you didn't grant it, you imposed it. And not all of us accepted it. And not all of us accept it now. I don't want your U.S. citizenship. And of course, we got into this whole debate, and I covered this on a couple of shows about this notion that Trump was challenging the birthright citizenship clause of the 14th Amendment. And he was citing examples on how it didn't include everybody. Well, you're right, it didn't include everybody. He tried to cite a Native example, which is kind of a stupid thing because we weren't included in the 14th Amendment. The 14th Amendment was what, 1868? It would be another 50 years before the United States would say, we're tired with all this mess with Native people. We're just going to impose U.S. citizenship upon them. We're going to declare that Native people are U.S. citizens. Wait, we don't have a say in the matter? And they said, no, you don't. We're just making this. That is, in 1924, that kind of action was already being considered a war crime. It was called denationalization. The idea of stripping away somebody's national character and imposing another nation's character upon them, that was considered, ethnic cleansing. It was considered a war crime. They would later develop the term genocide, which would include much of that. But before they even developed that term, they were calling this notion of stripping away somebody's national character and imposing another nation's character upon them, they were calling it a war crime. This came out of World War I. So the United States knew what they were doing. They knew what they were doing to us. But again, they didn't care. And why didn't they care? Because they had already developed this policy that says, well, we can do whatever we want to Native people. We can't do it to everybody else. But the Native people, We've already designated them as wards of the federal government, and we can grant them citizenship and never release them from that ward status. We still can control their lives. We still can pass whatever law we want about them without them. And that's where we're at today. And so it's amazing to me that we could have a conversation about the United Nations hosting the Permanent Forum on Indigenous Issues and never tackle this. And look, we have made treaty arguments. And in fact, there was the Yakima case where the state of Washington was trying to sue a fuel delivery, a native fuel hauler, for taxes. And it was called the Cougar Den case, and he fought them. The Yakima Nation submitted an amicus brief in that case, which had two parts to it. The first part was completely going after the doctrine of Christian discovery, the plenary powers doctrine, the trust doctrine, the trilogy of cases from John Marshall of the early 1800s. And the second part laid out the details of the treaty that the Yakima Nation had with the United States. The courts never really weighed in on the first part, never addressed any of the doctrine challenges that the Yakima Nation put forth. But they did it, and it's on the record. And I'm not saying it didn't have any effect, because I think the courts instead ruled almost unanimously in favor of the Yakima based on the treaty arguments, so they didn't have to address the other stuff on the first part of the brief. But here's the thing. Does the United States really recognize these treaties if they have imposed their citizenship upon us? I have a hard time getting this conversation started with anybody, because my argument is no nation has a treaty with its own citizens. So if we accept, or if the United States has accepted that they had the right to impose their citizenship upon us, did they wipe out all the treaties? Well, we'd have to say no, based on the Yakima case, based on the fact that some poor sucker in Washington has to requisition $3,500 worth of cloth every year to send it up to the Haudenosaunee to pay them for the Canandaigua Treaty. $3,500 worth of cloth. That gives me a swatch of cloth about the size of a Post-it note. Yeah, I'm holding a Post-it note up. If every Haudenosaunee person were granted a piece of that treaty cloth on an annual basis, it would take me a couple of years to be able to make a pillow. Forget about a ribbon shirt or a blanket or anything else. No, it's absurd. Nothing is, no cost of living expenses or increases, nothing like that. No, nothing like that. And yet you will not address any of the things that you did that violate not just the UN Declaration on the Rights of Indigenous Peoples, violated your own Constitution. And why? Because we are the exception. We are the people that the United States was able to exclude and create unconstitutional authority over us. And I'm sorry, folks, if you're listening to this show and don't get this, and if you are somehow opposed to dismantling these legal doctrines, then you're part of the problem. And I said this in a post recently on Facebook. I said, you're not just on the wrong side of history, you're just wrong. And we're going to fight you. And we're going to fight you. Look, I'm not the young guy I was, 30 or 40 years ago. But I'm not done yet, folks. And at some point, we are getting more and more people, not just because of our film, which, we're trying like hell to get people to see our film that talks about these legal doctrines, The Long Hope. We're doing a screening next week here at one of the more notorious bookstores in Buffalo, the bookstore called Burning Books. I mean, the proprietors of this bookstore have been like, they've got FBI files. They were basically being investigated as eco-terrorists. I mean, you can't make this stuff up. Again, there I go saying that again. But these guys truly have an independent bookstore. Not only do they have books that you probably can't find hardly any place else, but they host events like this. And we're going to do a screening of the Long Hope at Burning Bookstore at 420 Connecticut Avenue in Buffalo, New York. If you're anywhere in the neighborhood, and look, I say this all the time. If you're interested in a screening, please reach out. We're actually going to try to do some virtual slash live events where maybe we get some people in a room here, or you can get some people in a room there, and we can do a virtual screening of the film, and we can still do a Q&A. I realize not some people just want to sit in front of a laptop. Some people just want to sit in front of their phone. They don't want to go someplace. They don't want to go out. We've never really fully survived or recovered from the COVID crisis. So we're at a place in our time in our history that we're still much more comfortable just sitting in our homes, and we don't. I mean, we don't even visit friends the way we used to, but we still try to do these screenings. We try to do public events. We try to get the public to come out, and we're not getting great responses. I mean, we're getting great responses from the people who come, but we haven't filled a room. We haven't filled a theater. We haven't filled a lecture hall. But we're going to keep doing it. And little by little, people are starting to catch this, and they're starting to understand what we're talking about here. So I'll say it again. Treaties are not what people pretend or imagine them to be. What they were tools used against us. They were tools used against us, not only to force the federal government upon us. And again, the Felix Cohen Handbook on Federal Indian Law flat out says it. Native people came under U.S. authority through force and through treaties. And most of the treaties never said that. So it was through gross interpretations. It was through pushing us into smaller parcels of lands that too many times our own people are going to call federal lands rather than call them our lands. We'll do a whole nother show. I want to talk about land acknowledgement and where that can go and where it should go, because the idea of companies and institutions doing these land acknowledgements that basically say we are operating in the lands of the Haudenosaunee or the Lenape-Hoking or whomever, that doesn't do anything just to say it. We need to do something more than that. So we may be working with some folks to try to develop a plan for that. But we'll do a whole show on what land acknowledgement could be and should be versus what it is, versus the performative crap that most of it is. So we'll do that in the future. Hey, look, I want to thank you guys for joining me on this program. It is, as I said, it's always a pleasure to do this show in New York and in Washington. I hope you support the stations that carry the program, and you recognize that these stations are giving me the opportunity to reach you. And for that, I am grateful. I am John Kane. This is Resistance Radio, Yahweh.